In today's discussion, I'm going to take time to talk to you about the types of real property recording systems that we have in the United States of America. Primarily, I'm going to talk to you today about the difference between a tract index and a grantor-grantee index. And finally, I'm going to end our discussion today by talking to you about the three primary types of recording acts that we follow in the United States of America. To start off, in some jurisdictions in the United States, we use what we call tract indexes when we conduct public property records and title searches. A tract index is an index that identifies parcels by unique identifier numbers. Typically, we call these permanent parcel numbers. Each property is assigned a unique identifying number, and when it is bought and sold, transfers and records that reflect those transactions and those conveyances are reflected on the tract record index. Tract records and indexes are not all that common in the United States. You see these most frequently in large urban jurisdictions or states with larger populations. The more common type of index that we see in the United States, especially in rural communities and smaller states, is what we call a grantor-grantee index. Every time a piece of property is bought and sold or transferred or conveyed, a notation is made to indicate the name of the grantor. And also a notation is made in a grantee index to indicate the name of the grantee or the person who receives the property. So these are our most common types of indexes that we use in the United States. One thing I want to make clear is that in the United States, in every single county, there is a public official who is tasked and responsible for maintaining the real property records in that particular county, in the particular state. That person might be an official that we call the county recorder, and it varies from state to state. In some states, the probate judge or the surrogate court judge or administrator is the person who is tasked with this public responsibility to maintain real property records. But most commonly, in just about every state, this official is known as the county recorder. All right, moving on, I'm going to finish our discussion today by talking to you about the three types of prevalent recording acts that we follow in the United States. Recording acts are very, very important because number one, they allow for the public records to be searched. Every time a piece of property changes hands, there's a notation that's made on the public record on one of the indexes that I just mentioned a moment ago, either a tract index or a grantor-grantee index. So these are really important records to give the general public notice and knowledge about property transfers that take place in the community. One problem that we have sometimes in the United States is that property gets conveyed or transferred or sold multiple times. Sometimes this is done for a nefarious purpose or reason to defraud someone or take advantage of someone for the economic gain of the seller. So sometimes these things are done with ill intent. You might have a seller who sells property to A, and then a week later, they turn around and they sell or purport to sell the very same parcel of land to party B. So these are nefarious situations that sometimes take place. And sometimes property may be conveyed multiple times innocently and not knowing that there's anything wrong with that type of conveyance. Just to give you an example, let's say in 1950, someone conveys property through a general warranty deed, and then they turn around and they try to deed that same piece of property through a quitclaim deed to their sibling in 1955. There's maybe not ill intent, but sometimes you could have separate parties who purport to have ownership rights in the same piece of property. So, how do we try to alleviate these problems and these situations where you have multiple claimants who are claiming interest and title in the same piece of property? In the United States, we have recording acts. The first type of recording act that most states in the United States early on adopted was what we call a race recording act. And literally, whenever someone gave you a deed or title to a piece of property, your job was to race to the recorder's office and get your deed recorded. That was very important. The first person who got there first and who was in line to record their deed first, and who in fact did record their deed first, would win over all subsequent claimers who claimed an interest in the same piece of property. Race statutes have fallen out of vogue. Race statutes were good in the sense that they promoted efficiency and quickness in terms of the recordation of deeds. And the other advantage of race statutes was that they did not require any sort of inquiry off the record. It didn't matter if someone had sold the same piece of property to someone else, whether they had done so innocently or with ill intent. That did not matter. The biggest part of the discussion was whether or not you got to the recorder's office first, and that's all that mattered. Unfortunately, in the United States, as we see today, race statutes are only found or still exist in two jurisdictions, and those jurisdictions are Louisiana and North Carolina. So as we can see, race notice statutes have fallen out of vogue in the United States. There's a second type of statute that we use, and that is called a Notice Recording Act. Under a Notice Recording Act, it all comes down to notice or knowledge. Whether or not you knew that there was a prior unrecorded deed to the same piece of property. If you knew that and you bought that piece of property and you subsequently later on recorded your deed first, you would lose under a notice statute because you had knowledge or notice that the seller had conveyed the property to multiple parties or someone before you prior in time. So under a notice statute, everything focused on state of mind and what you knew. Did I know that the property had been sold before? Did I have notice, either actual, constructive, or inquiry notice that that property had been sold before? Notice statutes are still found in about half of the states in the United States. Notably, these statutes are found in Illinois, Massachusetts, Texas, and Virginia. We're going to end our discussion on the final type of recording act that's recognized and still followed in the United States of America. And that is what we can kind of call a hybrid or mix between a race statute and a notice statute. The third type of prevalent recording act that we follow in the United States is what we call a race notice statute. Meaning, number one, if there's a bona fide subsequent purchaser who purchases an interest or acquires title to a piece of property, if they don't have knowledge or notice of any prior conveyances of that property, and couple that with recording their deed first, if they get there first and they're first in line, if they record first and they don't have knowledge and notice, then they win and prevail over subsequent purchasers who might claim an interest in the very same piece of property. So race notice statutes, number one, encourage efficiency because the idea is that you have to get to the recorder's office first. And then number two, it inquires into the state of mind of the purchaser. Did you have notice or knowledge about a prior sale or a prior deed that might be out there for the same piece of property that you're claiming an interest in? Race notice statutes are followed in about half of the jurisdictions in the United States. Notably, race notice statutes are on the books and on the records in Georgia, Michigan, New Jersey, New York, and Ohio, just to name a few different states. All right, that concludes our discussion of the Recording Act and the Recording Acts, the three types of recording acts in the United States, and a general discussion on the nature of the public real property recording system in the United States. Thank you for watching.